So we're going to now look at the issue of gross negligence manslaughter and ligature deaths in custody. And we're going to look at it in relation to the staff liability and also organisational liability. So first off, if I take you back to a case that we introduced you to earlier, which is the 2019 case where two mental health nurses were charged with unlawful killing of a 22-year-old woman. And those members of staff went to Crown Court in relation to the manslaughter. Now here we have an extract from Guernsey Press, which was dated the 27th of September of 2019. And the headline was, Ellis case, nurses cleared after death on mental health ward. So two nurses have been cleared of causing the manslaughter of a patient by gross negligence at the Oberland's mental health 2 years ago. So the jury took about 90 minutes to reach the decision at the end of a 17-day hearing. And the senior juror on the bench told the court that they had found both defendants not guilty with a 7-2 majority. Lauren Ellis died at the Oberland's Mental Health Centre in the early hours of Thursday, the 12th of October 2017. A post-mortem found she had died through ligature strangulation. Rather than looking at it subjectively, the court faced an objective test. To achieve a conviction, the prosecution did not need to show that there had been intent, but there had been gross negligence. The court had heard how both defendants had been supposed to carry out checks every 15 minutes on Miss Ellis, but 6 checks were missed in a row and there had been 1 hour and 42 minutes between the last check and the discovery of what happened. Both defendants also accepted falsifying entries on the observation record log. And note here that Lauren died whilst a patient. She used the bandage that she'd been given at the emergency department to ligature herself. Now, if a person dies in custody through a ligature death, then it may be 2 categories of principles. So here we've got the staff members themselves and we've got the business. So in relation to the staff member, they may then be investigated as a principal offender for the likes of manslaughter offences or as an accessory, so such as aiding, abetting, procuring or counselling the offence. The business, so the organisation, they might then be investigated in relation to the offences of corporate manslaughter, Health and Safety at Work Act offences or vicarious liability. And also the avenues that can be taken after the event is both criminal and civil. Now, when we look at the heading of unlawful killing, so an inquest concludes now on the balance of probabilities for unlawful killing. So they only decide, are the people responsible on the balance of probabilities for unlawful killing. An unlawful killing verdict at an inquest may not result in a conviction at Crown Court. Manslaughter by gross negligence can only be brought against people, not companies, and corporate manslaughter would be considered for the company or the organisation. So let's look at gross negligence manslaughter. So this is manslaughter at common law is capable of being committed by negligence. It can be committed by an act or an omission. So the offence of gross negligence manslaughter, G&M, is committed where the death is a result of a grossly negligent through the otherwise lawful act or omission to the part of the defendant, on the part of the defendant. Death in custody. A death in custody is a generic term referring to deaths of those in the custody of the state. In this context, the offence can be committed by police or prison officers, dedicated detention and other custody assistance, and by healthcare professionals who are responsible for the care of those detained in a custodial setting. Death results from a negligent breach of a duty of care owed by the defendant to the victim. So in order to prove the offence, the prosecution must therefore establish the following elements. Firstly, the defendant owed a duty of care to the deceased. Secondly, by a negligent act or omission, the defendant was in breach of the duty which he owed to the deceased. Thirdly, the negligent act or omission was a cause of the death. And fourthly, the negligence, which was the cause of the death, amounts to gross negligence and is therefore a crime. Now, those with a duty of care must act as a reasonable person would do so in their position. If they fail to do so, they will have breached their duty. The standard of care to be applied should be a reflection of the extent of the duty of care. For example, what are required standards expected of a staff member in the situation? So here's where we might look at, for example, the Care Quality Commission guidance, or the College of Policing guidance, or the Prison Service instructions. In many situations, the law already recognises that a duty of care will exist, for example, by employers to their employees, and by healthcare professionals to their patients, and custody staff to those detained in their care. When a person has created or contributed to the creation of a state of affairs, which he knows or ought reasonably to know has become life-threatening, a duty on him to act by taking reasonable steps to save the other's life will normally arise. And a stated case here is R versus Evans of 2009, if you want to look this up. But a quick summary about that case is here. So Evans purchased heroin and gave it to her half-sister, who later self-ingested the drug. Evans recognised that the victim had symptoms akin to those of an overdose and remained with her mother and the victim without calling for medical assistance as they feared getting into trouble. They checked on the victim at intervals throughout the evening, and when they awoke the following morning, the victim was dead. The cause of death was poisoning from heroin. The primary dispute in the first instance was whether the supply of drugs to her half-sister had created a duty of care between Evans and her half-sister. The jury agreed that there was a duty owed, and Evans was convicted. Evans subsequently appealed. The appeal was dismissed, and it was held that none of the previous authority Evans referred to had dealt with manslaughter. It was held in cases of gross negligence manslaughter, if an individual caused or contributed to creating a life-threatening situation, a consequent duty would normally arise to take reasonable steps to save the person's life. On the facts of this case, Evans created such a situation by providing the heroin to her half-sister and not taking subsequent steps to negate the danger created. Now, in relation of breach of duty, the ordinary principles of the law of negligence apply to determine whether the defendant was in breach of a duty of care towards the victim. Whether or not sufficient care has been taken by the individual to discharge the particular duty of care placed upon him is tested by the objective standard of reasonableness. In considering a breach, the jury must consider objectively what a competent person fulfilling the same role as the defendant would have done. And so, for example, the conduct of a doctor, electrician, or builder who is accused of the offence is assessed by comparison with the competent doctor, electrician, or builder would have done in the same position and circumstances as the defendant. If what the defendant did is not contrary to the actions considered appropriate by a responsible medical, electrical, or building opinion as relevant, then their conduct will not be considered negligent. So basically, whatever custody role you're in, the court then would be looking at somebody in your same position, in your organisation, nationally, what would they normally do? And would they have done the exact same as you? Or would they have done something different and it was you that was out of sync with others? However, the standard of care is objective and such does not take into account the weaknesses or inexperience of a particular defendant. So you can't use the excuse that you're new or young in service. The fact that the defendant has not been sufficiently or adequately trained is not a relevant factor in establishing whether they breach their duty of care, but it can be relevant to the question of whether gross negligence can be established. On the other hand, if the defendant has particular skills or knowledge that ordinary reasonable person would not have, their acts should be judged in the light of those skills or knowledge. The breach of duty must cause the death. It does not have to be the only cause, nor even the principal cause of the death, but it must have more than minimally, negligibly, or trivially cause the death. The burden rests with the prosecution to establish causation. It is unnecessary for the breach of duty to have been the sole or even the main cause of death, providing it contributed significantly to the victim's death. It is not the function of the jury to evaluate competing causes or to choose which was dominant, providing they are satisfied that the defendant's actions could fairly be said to have been a significant contribution to the victim's death. And a case there that you might want to look up is R versus Cheshire of 1991. In cases where there's been an omission to act, the prosecution must prove that the negligent failure to act was a substantial cause of death. Now, in determining whether sufficient evidence exists for a realistic prospect of conviction, prosecutors need to also consider how the courts have determined the degree of negligence required for the offence. A breach of duty must be so bad as to be gross, i.e. criminal. This was defined in Adomeko in 1994. Having regard to the risk of death involved, was the conduct of the defendant so bad in all the circumstances as to amount to a criminal act or omission? The prosecution must prove the following two elements. Firstly, that the circumstances were such that a reasonably prudent person in the defendant's position would have foreseen a serious and obvious risk of death arising from the defendant's acts or omissions. And secondly, that the breach of duty was, in all the circumstances, so reprehensible and fell so far below the standards to be expected of a person in the defendant's position with their qualifications, experience and responsibilities that it amounted to a crime. Now, when we look then at the business and the corporate manslaughter side, corporate manslaughter is an offence created by Section 1 of the Corporate Manslaughter and Corporate Homicide Act of 2007, and it came into force on the 6th of April of 2008. The offence was created to ensure that companies and other organisations can be held accountable for serious failures resulting in death. Under the 2007 Act, the offence of corporate manslaughter relates to the way in which the relevant activity was managed or organised throughout the company or organisation. Wider considerations such as the overall management of health and safety, the selection and training of staff, the implementation of systems of working and the supervision of staff can be taken into account. An organisation is not liable if the failings were exclusively at a junior level. So if your employer, an organisation, has provided you with all the correct training that you should have had, but you choose not to comply with that and do something else, then you are responsible. If, however, your organisation has not provided you with the training, guidance, skill that you should have, then it rests with the organisation. Now, the failings of senior management must have formed a substantial element in the breach. However, the failings at senior management level do not themselves have to amount to a gross breach of duty. Liability for the offence is assessed by looking at the failings of the organisation as a whole. The prosecution must prove that the breach of duty was causative of death. The test is whether the breach made a more than minimal contribution to the death. Because the defendant is a corporate body, the penalty must be a fine. With effect from February of 2016, the level of sentence will depend on the size of organisation. The sentence range is specified as between £180,000 to £20 million. The offence of corporate manslaughter is indictable only. In England and Wales, proceedings may not be instituted without the consent of the Director of Public Prosecutions. The offence is created by Section 1 of the Act, which provides as follows. So the offence, an organisation to which this section applies is guilty of an offence if the way in which its activities are managed or organised causes a person's death and amounts to a gross breach of a relevant duty of care owed by the organisation to the deceased. An organisation is guilty of an offence under this section only if the way in which its activities are managed or organised by its senior management and is a substantial element to the breach. An organisation that is guilty of corporate manslaughter or corporate homicide is liable on conviction, on indictment, to a fine. So let's imagine, for example, whatever custody sector you're in, there's a management decision to save money, and they say, all these new recruits that we've got coming through, we're not going to give them the training. We're just going to let them run the ward themselves on their own, so they don't know anything about suicide risks, ligature risks, levels of observation, and the decision is made that they'll run with that risk. That then, if you look at corporate manslaughter, they have not provided the level of training in relation to what they should. And also then, if something goes wrong, the individual can then point out the fact that they were never trained in relation to recognising anything neither. Now, the following needs to be proved. The defendant is a qualifying organisation. Well, all custody settings are qualifying organisations. The organisation owed a relevant duty of care to the deceased, so that is also ticked with custody. There was a gross breach of that duty by the organisation. So here it's about then looking at ensuring that all staff on duty are trained to the required standard, and we're not then left with staff who are on duty without the required training. The way in which its activities were managed or organised by its senior management was a substantial element in the breach, and the gross breach of the organisation's duty caused or contributed to the death. Relevant duty of care is defined by Section 2 of the Act. A relevant duty means any of the following duties in the law of negligence. So a duty owed by an employer to its employees and other workers, a duty owed as an occupier of premises, a duty owed in connection with the supply of goods or services, a duty owed in connection with construction or maintenance operations, a duty owed in connection with the carrying on of any other commercial activities, a duty owed in connection with the use of keeping of any plant, vehicle or thing, or a duty owed by reason of being responsible for the safety of a person in custody, secure accommodation, or as a detained patient. So this covers all of our UK custody sectors, whether it's adult, child, police, prison, mental health, whether the person is there voluntary or not. Deaths in custody, the provisions relating to deaths in custody are set out in Section 2, and these came into force in September of 2011. They encompass detention in prison, detention in police custody, immigration detention, transport of prisoners, detention of children and young people in secure accommodation, and detention under the Mental Health Act of 1983. Now, CPS charging standards give some advice in relation to the use of expert evidence. So this would include myself when I act as an expert witness in relation to deaths in custody. In many cases, expert evidence will be critical to establishing whether or not there was a gross breach of duty. For example, it may be relevant to consider whether the organisation conducted its activities in accordance with published guidance and or the recognised standards of the industry. So that there is quite a significant bit of what my reports go into, to look at what were the organisational requirements, but also what are the recognised standards. So even if that particular sector was not doing something, if all the other sectors were already doing it, why did that sector fail to recognise this and adopt it? Because ultimately everyone should be complying with the UK standards. Expert evidence may be required to assist both in relation to the activity which directly related to the death, for example, safe systems of working adopted, or suitability of equipment. So they were looking at your safe systems of work with the likes of the Health and Safety at Work Act, and also the adequacy of the organisation's overall systems for the management of health and safety and the supervision of its staff. Expert evidence on the former is likely to be industry specific. On the latter, opinion evidence may be provided by experts within the Health and Safety Executive or by independent health and safety consultants. Now, also to consider in relation to alternative charges. So many cases in which a charge of corporate manslaughter is under investigation will involve liaison with the Health and Safety Executive, a local authority or specialist regulator. Prosecutors may have to consider the inclusion of charges under the Health and Safety at Work Act and safety regulations when charging corporate manslaughter, gross negligence manslaughter, or other related offences. Now, when we look at some specific cases during the training, we'll also look at how typically the organisations have not been pursued under corporate manslaughter, but they've pled guilty in relation to failings under the Health and Safety at Work Act. And that is the end of that presentation. Any questions in relation to the law, don't hesitate to contact us, and I'll see you on the next recording.